than one person in the room who may have worked on the same matter, so that in case some person doesn't recall a particular decision, action, activity, the other person might, and that might click the memory of the person who we were originally questioning. So it really depends on the circumstances. Now, in hindsight, given this matter, obviously this seems somewhat unusual. I need to do a little more research.
This is just 30 seconds. Based on what the chairman just read, it sounded like Ms. Paz was, she felt like she needed to be in the room because she wanted to be able to defend herself or the agency, I don't know, based on what may have been said or information gathered in that interview. And that seems like it goes against what you just said.
But again, hindsight is 2020.
Right. Okay. All right.
Thank you. I thank you for your comments. We now go to the gentleman from Florida.
Thank you, Mr. Chairman. Thanks to witnesses for toughing this out. I'm just a little still stunned by the beginning of this hearing. We are investigating the IRS targeting groups who, among other things, educate about the Constitution and the Bill of Rights, and yet we have one of the officials potentially responsible for that invoking one of those constitutional rights. So it was a startling thing. Let me ask Mr. Wolin, just so I get this right. IRS reports essentially to the leadership of the Treasury Department and then the President. Is that the proper chain of command, so to speak?
It is, Congressman.
Okay. And Mr. Schulman, I noticed that you've made obviously a lot of trips to the White House. That was discussed. You also have met with the President in 2010, one occasion, and then twice in 2011. Is that correct?
I don't know the exact dates of meetings, so
I didn't ask the dates, but is that about 3 times during that period? Is that, I mean, we just have the log. That's what it says. June 29th, 2010, February 3rd, or excuse me, June 6th, 2011, and December 2nd, 2011.
I have memory of 2 of the meetings. I'm not sure I have memory of the
Now, we don't yet have the log for 2012, but did you ever meet with the President in the White House during 2012?
Was the last date? Could you give me the last date?
The last date that we have is December 2nd, 2011.
I'm sorry. I was referring to a December 2012 where I had a photo taken with my family.
So is that the only date you remember from 2012?
So my memory, that's the only date I have any memory of with the President in 2012, except for perhaps a holiday party or some such.
Okay, so when you were going there, were those discussions, or what were those discussions about? The Affordable Care Act, 501c4s?
The discussions with
the President?
I don't remember having extensive conversations with the President. The first conversation that you referenced was about the tax gap and tax collection in general and how the IRS works and how to collect the proper amount of revenue for the government. It's my best recollection.
So that is the extent of the substantive conversations you had, or were there other topics discussed? I mean, I understand you were busy. I understand you meet a lot of people, but most people probably remember when they meet with the big guy.
No, that's the extent of my memory, and I also, now that you bring this up, I haven't looked at these dates. I'm not at the agency anymore. I also had a discussion once where he convened a number of agency heads talking about how to improve the government generally.
Now, according to these logs, it was pointed out that there were over 100 times where you visited the White House, generally, I think 118, and there are 46 of them where there's a purpose of health care, and it looks like it started in April of 2010 and really continued throughout 2010. So when you were going to discuss health care, was that specifically to discuss the Affordable Care Act, aka Obamacare?
The IRS was tasked by Congress to have a role in the Affordable Care Act, and I had a number of conversations with at OMB and the White House about that.
One of your predecessors, Commissioner Everson, he testified about this issue with the Affordable Care Act. He said that he didn't really recall ever going to the White House for policy discussions. I think he said he may have gone one time, and he said that he worried about the IRS being this intimately associated with kind of a signature initiative, that it may actually hurt the IRS ability to conduct its core function of tax collection. Do you believe that there's a danger in that?
I believe the IRS is part of the executive branch, and when it's tasked with a major job of implementation, it needs to have proper coordination.
Well, that didn't really answer the question. I mean, putting this new, which could be a very intrusive burden in terms of American citizens having their health care being involved with the IRS, to be able to do that is obviously going to require resources and manpower. And I guess my question is there a danger that could take away from the traditional functions of the agency?
The IRS is, when people think about the IRS, they think about collecting taxes. They don't think about figuring out application for tax exempt status. They don't think about a lot of things. So over the years, Congress has loaded the tax code with many, many different functions, all within the tax code, and the job of the IRS is to administer the tax code. So I really, the IRS is going to do what Congress asks it to do.
All right. I just note that still didn't really answer the question, but I will yield back to the chairman. Thank you.
I thank the gentleman. We're now going to go for this last 5 minutes that I mentioned each side. Mr. Cummings.
Thank you very much, Mr. Chairman. I'm going to be very brief. And this is something that we have not talked about yet, and it's something that I just want to get you all's opinions on. Mr. George, there are some organizations that if the tests for tax exemption under these circumstances were administered fairly, might not meet the test. Is that a fair statement? You understand what I'm saying? In other words, there's a law, there are standards, and some organizations, I'm not talking about the ones here, but I'm talking about generally, might not meet the test
I guess
for tax exempt status.
I'm sure in theory you're accurate.
Yeah, I'm talking about in theory.
Yes.
Let me tell you what I'm really concerned about, in addition to all the other things that I've said. I'm concerned that all of this may have a chilling effect on employees, where they say, when normally we would, look at certain criteria fairly, not targeting anyone, but say, uh-oh, I'm worried because I better let this go. Let's say, for example, we were talking about audits. And they said, uh-oh, I'm not going to do this because I may be called in and told that I didn't do things properly. Are you following what I'm saying? And so then the organization does not do what it's supposed to do. Are you following me?
And not only am I following you, sir, there's evidence to that effect with the passage of the Restructuring and Reform Act of 1998, and with the deadly sin, the top 10 deadly sins, there was a steep fall off in IRS enforcement because IRS employees were afraid to be very aggressive as it relates to trying to recover money.
And I'm just wondering, how do we strike that balance? I know one thing, Mr. Wallen, is making sure the law is clear. Another thing is making sure that there's some kind of guidelines that are consistent with fairness. What else can we do? Because we got to have that balance. We cannot have employees who are sitting there shaking like a leaf on a windy day, believing that if they fail to properly do what they're supposed to do, they may get in trouble. But they also have to know that what their guidelines are. And I'm just curious, now you said that you're going to have a conversation with Mr. Woelfel, the new commissioner acting, and I'm just telling you, I'm trying to figure out how does all that, taking what I just said into consideration, how do we help him to create an atmosphere where the employees can still do what they are supposed to do in the way they're supposed to do it, without feeling threatened. Does it make sense?
It makes complete sense, and just to be clear, it's more than a conversation, Congressman. We are going to work with Mr. Werfel. If he has the ability to make sure that his employees are trained, if they know that they have his confidence and he has their back, I think it'll help address some of the concerns that you're alluding to, sir.
Mr. Wallen, do you have a comment?
Congressman, I think that it starts with leadership. He has, I think, an impeccable record, Mr. Werfel, and is very well suited to hit the ground running to make sure that he starts the path toward restoration of not just the public's confidence in the IRS, but also, as you're pointing out rightly, sir, the employees' capability to do the job, the important job they need to do. And I think that that partly is about holding people accountable for misconduct that occurred, and it's partly about putting in place procedures and policies and a culture that makes sure that these kinds of things don't happen again, that people are appropriately trained, that there's clarity about what the rules are, and so forth. And that's a process that he's begun today and will really move forward with focus on, and with our full support.
As I said at the beginning of the hearing, this is about trust and truth. And I want to thank all of you for being here today. This is an ongoing process. But I want us never to forget that it's not enough to just investigate. We've got to bring about reform. And this is I think there are moments that come in life, as I close, Mr. Chairman, there are moments in life where incidents happen. And at that moment, we must take advantage of the moment, because the moment will tell us that we need to change things and do something in a different way. But if we let that moment pass, usually things only get worse. And so I'm hoping that you all will, I know you left, Mr. Schulman, but I hope that we can get your cooperation in any way that you may be able to do it. Mr. Wallen, Mr. George, I hope you'll keep that in mind, because the American people are very concerned about this. And Mr. Chairman, I want to thank you for, I think, what has been a very good hearing.
Thank you, Mr. Cummings. Out of the 5 minutes, I yield 1 minute to the gentleman from North Carolina.
Thank you, Mr. Chairman. Mr. Schulman, with this internal investigation that was done originally, am I correct in the person that headed that up, that left from Washington, D.C., and went to Cincinnati, was actually the special advisor to Sarah Hall, who is now over our health care? Is that correct? Mr. Miller employed her to go and do this internal investigation.
As I stated earlier, I don't know it to...
So you have no idea what happens below you at all?
No, that's not what I'm stating. That I actually didn't know it and didn't to be an internal investigation.
But you agree that it was her, and she is the special advisor to Sarah Hall, who is now over our health care?
The best of my understanding, and I've read the report, that's where I see it was special advisor.
Did you ever talk to Mr. Miller about that? Who was going to head it up?
think...
Do you know who Miss Marks is?
Yes, Nancy.
Okay. Was she the special advisor to Sarah Hall?
I don't know. I think at the time, my best recollection is she was special advisor.
There's two
to
C's
Joseph
here.
Frank.
Either there's a cover-up, or it's an extreme lack of curiosity on your part. I yield back.
I thank the gentleman. We now go to the gentleman from Ohio, Mr. George.
I thank the chairman, and I want to direct my questions to Mr. George. Let me first, putting aside the fact that I do think the audit was compromised by what both the chairman and the ranking member asked you about and talked about earlier, with the interviews being conducted in the way they were, with Ms. Paz present in almost all of them. But what I want to go to is the timeline you gave us, the TIGTA timeline. And on March 8th, you all meet with Oversight and Government Reform staff. You meet with the folks back here, and you talk about this issue. Then you decide to do an audit. On that meeting took place March 8, 2012, when you first met with Oversight staff. Then you decide to do an audit. On May 29th, you brief the IRS. May 30th, you brief the IRS about some preliminary findings. You give them a heads up, but it's not just a heads up about we're doing an audit. It's a heads up we're doing an audit, and oh, by the way, we have discovered that Tea Party Patriots 912 identifiers were used in groups applying for tax exempt status. Looks like 5 days later, June 4th, you give the same kind of heads up to the Treasury General Counsel, Chris Meade. So I really only have one question. Why didn't you give us a heads up?
Actually, Congressman, if you look closer to the top of the timeline, it was March 1st that my office was contacted by staff of this committee.
Right.
And we were requested by this staff to look into the matter.
No, I get that. We asked you to, but a few months later, you're telling both the IRS and the Treasury Department that so far in this investigation, we have uncovered that Tea Party Patriots and 912 were used to identify groups and single them out for different kind of treatment. Why didn't you tell us the same? We'd like to know that information. All we knew from you was, okay, we're doing an audit. In fact, we hadn't even formally requested the audit. Mr. Issa and I sent a letter to you on June 28th. You've already given those guys, the IRS and the Treasury, the guys sitting beside you, you've already given them a heads up about some initial findings. We didn't. The first time we heard about that in any public way was a few weeks ago. So all I'm asking is, why didn't you afford us the same opportunity you gave them and say, oh, you know what? We are doing an audit, and we found that these terms were being used.
But again, sir, if you look through the timeline, there have been communications between...
Yeah, but you have never once told us what you just wrote in writing. You told them. You think it makes sense for people to ask the question? You're giving a heads up to the Democrat administration about the terms Tea Party, Patriot, 912 being used, but you're not going to give a heads up to the Oversight Committee, the very committee who oversees the Inspector Generals in our government, the very committee who asked for the audit, and you don't give us the same heads up, which includes those identifier terms? You don't think that's unusual in an election year?
The gentleman's time is expired. Please go ahead, Mr. George.
Sir, I was not at these briefings, so I'm not certain as to exactly what information was communicated.
This is your stuff. You lay it out. You tell them those terms, and you don't tell us, and somehow that's fair, and we're the ones asking for the audit?
But once again, sir, this is not exhaustive in terms of what was communicated, and but those were...
So are you telling us you told this committee about the terms Tea Party, Patriot, and 912 being used in 2012? You instructed this committee that those things were being used in 2012. Did you ever communicate with anyone on the Oversight Committee or any member of Congress about that?
The gentleman may answer, but that'll be the end.
Yes, I did not have discussions with...
Of course you didn't. You just talked to them.
My staff did, sir.
Thank you. I really have no time left from the 5 minutes, so I will close this by saying that we will work. I've directed my staff to work along with the minority staff on an analysis with your office of the timeline of the initial audit period, and quite frankly, to come up with some future guidelines as to when an audit should turn to an investigation. I understand from your earlier testimony that when an investigation begins, an audit ends. It is a consideration of this chair that there was a time during this audit in which the knowledge was sufficient of the primary activities that did occur, that an audit at least possibly should have been converted into an investigation, which I think would have changed a great deal of the procedures that we've had a discussion about here today. I'm not going to make any further judgment this time. I'm going to ask my staff to work with your staff and the minority staff so that we can sort of put this together into a package and not be doing not limiting to this preliminary timeline, if that's acceptable with you, Mr. George.
It is, but again, sir, we can speak offline, and because
thank you.
There are certain protocols. These are law for criminal versus civil.
Right, and that's the reason I think this hearing is not the place to go flesh it out further. And with that, excuse me, at the beginning of this hearing, I called 4 witnesses. Pursuant to a subpoena, Ms. Lois Lerner arrived. We had been previously communicated by her counsel, and she was represented by her own independent counsel, that she may invoke her Fifth Amendment privileges. Out of respect for this constitutional right, and on advice of committee counsel, we in fact went through a process that included the assumption, which I did, which was that she would not make an opening statement. She chose to make an opening statement. In her opening statement, she made assertions under oath in the form of testimony. Additionally, faced with the interview notes that we received at the beginning of the hearing, I asked her if they were correct, and she answered yes. It was brought up by Mr. Gowdy that, in fact, in his opinion, as a longtime district attorney, Ms. Lerner may have waived her Fifth Amendment rights by addressing core issues in her opening statement and the authentication afterwards. I must consider this, so although I excuse Ms. Lerner, subject to a recall, I am looking into the possibility of recalling her and insisting that she answer questions in light of a waiver. For that reason, and with your understanding and indulgence, this hearing stands in recess, not adjourned.
You can't comment on the particular cases, but would you expect some of those to be confirmed leaks from the IRS of confidential information? Or in the past, have you ever?
Fortunately, I'm being instructed by counsel that I cannot acknowledge the results of those investigations, Congressman.
Okay. Can you acknowledge results of prior investigations? Can you acknowledge that a leak has ever been confirmed, that anybody's private information has ever been released?
We don't have an answer to that, sir.
Okay. Mr. Chairman, we need more hearings. We need more investigations. We need to get to the bottom of this. I think people working for the government right now need to be fired for abusing the public trust. But let's not delude ourselves. We're just treating a symptom of the disease. And the disease is a bloated, abusive government that has become self-serving. We've seen that Mr. Shulman has stated he can't be held responsible for 90,000 employees. I doubt any man or woman could be held responsible for a bureaucracy that's 100 years old that has that many employees. We sit here comfortably on the dais questioning three men here today, but I think Congress created this monster. We need to look inward. We have 70,000 pages of tax code, 90,000 employees that work for this bureaucracy. And a lot of this tax code is open to interpretation. I think it's ripe for corruption and abuse. And I think in order to restore trust, the public trust, we're going to have to address this issue. And I think Congress needs to take it upon itself after today to shrink the size of the IRS, to simplify the tax code, and to restore the public trust. Thank you, and I yield back.
We now go to the gentlelady from New Mexico, Ms. Luann Grissom. They're not tax deductible. This is about the entity not paying taxes, as I understand it. If you're declined a 501c4 status, some of these organizations, 3 years, under certain circumstances, you then have to pay corporate taxes on this as though it was income. You then could even have your officers and directors personally responsible. But it's not a C3. These are C4s, and I'm sure that we have people here that could define the difference, but it's real important to understand this is about if you were, for example, were determined to be a 527, nothing would change, except, as you said, the potential names. 501c4s, 527s, the difference is not really a taxable event.
Mr. Chairman, I appreciate that clarification. However, if I'm not clear that some of these organizations provide the right disclosures, I'm not clear that folks who are providing donations to those organizations are clear about those rules, I'm not clear based on the scope of this investigation to date that we've got clarity about whether folks really are qualified as a 501c3 or a 501c4. And as we uncover more information about those donors, those differences, those investments, and the engagement of activity of these organizations, it seems to me if there are violations made, the disclosure of donors in a violation and taxes be recovered if they so apply should be done by the IRS.
I appreciate the gentlelady's comments. Would somebody clarify for the record the taxation policies so that that can be clear? Because I think there's Mr. Shulman, you certainly know the difference. There's obviously a huge misunderstanding as to the taxability and the ramifications, what you really get on a 501c4 versus 527.
There's a chart actually in the Inspector General's report, I think, that has the different taxable entities and the different.
Right. I mean, 501c3 is a big deal. 501c4 or less. Mr. George? To the extent that you can answer to clarify for the lady.
Yes, oh, certainly. A 501c3 may do the following. They may receive tax-deductible charitable contributions. They may not engage in political campaign intervention. They must publicly disclose the identity of their donors. They may not disclose the identity of their donors. They may engage in lobbying, limited but must not be substantial. They may engage in general advocacy not related to legislation or the election of candidates, but it has to be as an educational activity, and they must apply with the Internal Revenue Service for their 501c3 status. Now, as to 501c4, 5, and 6s, none of their contributions are tax deductible. They may engage in limited political campaign intervention, but again, it may not be their primary activity. They do not have to disclose the identity of their donors. They may engage in lobbying, but it has to be actually they have an unlimited amount of ability to do that if it's in furtherance of the taxes purpose for which they were established. As it relates to general advocacy, they may also do so in an unlimited way as long, again, as it's in furtherance of their tax-exempt status, and they do not need to apply to the Internal Revenue Service for this status.
Thank you. The gentlelady, I presume, is satisfied.
I'm not, Mr. Chairman.
Well, we'll make additional information available, but I
Can I
think
make
it's
one statement, Mr.
Of course.
Chairman? Thank you so much. To the issue that in a 501c3, which I'm clear about the differences between, and I appreciate doing that for the record, sir, 501c3s and 501c4s, donors are not required, you don't have to, the 501c4 doesn't have to disclose the donors. Right. If they have violated that political activity premise, just like a 501c3, I'm making the argument here that they should have to then disclose those donors. And now that you're disclosed, I want to make sure that appropriate taxes have applied to that person's personal income as a result of knowing that they've made contributions that were not disclosed in any form, so that there is a double check. In the same way that the IRS receives independent information about my income, what I receive and what I don't receive.
Well,
That's my point.
the gentlelady may
Chairman.
turn the tax code upside down if she would like. I suggest you find co-sponsors, but the fact is that these individuals give money post-tax. They pay their taxes and then they give the money out and they do not control the organization. So the idea that they would take on personal responsibility for their contributions and somehow be double taxed, perhaps the gentlelady would reconsider the chilling effect, whether it's a 501c3 or 501c4. With that,
Follow up on some of your line of questioning there as it relates to, and I want to make sure that I understand you, Mr. George, on May 29th of 2012, almost a year before the official report came out, you were briefed, and as my understanding, you specifically knew at that particular point that there was a criteria that was being used to target the Tea Party Patriots 912 group. Is that correct?
Actually, sir, that was my final briefing on this matter during the course of the audit.
Okay, but this is May 29th, 2012. Is that correct?
That's correct.
All right, and so on May 30th, the day after that, you actually briefed Mr. Schulman, Deputy Commissioner Steve Miller, and Beth Tucker on this new audit, and using that same criteria that it was being used against Tea Parties. Is that correct?
Sir,
That's what your notes say.
Yes, but my colleagues behind me who were in attendance at the meeting.
Right, it said function heads, so I assume that they were your function heads.
And they indicated we had some indication at the time that the allegations had merit, but we did not characterize. We cannot. I'm not in a position now to characterize the level of detail that we had at that point.
I'm not asking about detail. Was there a separate criteria used for those groups? A separate criteria used for Tea Party groups that you just admitted to just a few seconds ago.
You know, again, sir, I'm not certain as to exactly.
Well, as your function heads, are y'all familiar with it? We have notes that would indicate that there was a separate criteria used.
Yes, sir. I was just informed that we knew there was a criteria. We didn't know the nature of the extensiveness of it, sir.
So we know that it was separate, though.
Yes.
And you, the gentleman to your left, you did notify him of that on May 30th of 2012.
That is my recollection.
Okay. Then on June the 4th, this note says that you briefed the general counsel, Mr. Chris Meade. So you briefed him of a separate criteria in the Treasury Department on June the 4th, 2012. Because all of a sudden, you know, all of this is supposedly it's just happened, but this is well over a year ago. So you briefed the general counsel, the chief general counsel of the Treasury Department well over a year ago.
I did, but I have to acknowledge that in the briefings that we hold with the Commission of the Internal Revenue Service, I have my subject matter experts in the room.
So you went by yourself to the general counsel, and so you may not have given them the complete story.
I'm certain that I did not give the level of...
Why would you have not given them the complete story if you had just done it a few days before?
Well, because the commissioner...
The document that you've given us, it was in the document that you've given us, so are you just giving us stuff that you're not aware of, Mr. George?
I don't know which document you're referring to, sir.
Well, I'll be glad to give it to you. I just find it highly inappropriate.
Sir, this was put together by auditors, as you can see, some of whom are in Washington, many of whom are in Washington, but some of whom are not. These are level.
Well, that's my point. This is not isolated to two people in Cincinnati. This has a whole lot of people in Washington, D.C. And why would she have been part of it? Would you normally conduct an audit in that manner?
You know, the gentleman's time has expired. You may answer that.
Congressman, I would respectfully request the opportunity to look further into this and to report back to the committee, because this is the first time that I was made aware of this, and I really don't have information about it.
I thank the chairman.
Thank you, and we will allow the gentleman time to do the research and get back with us. We now go to the gentleman from California, Mr. Cadaris.
I don't know the answer to that question.
Yeah, the answer is no. I understand that they take training classes on ethics, but specifically about the Constitution and Bill of Rights, you don't know that. Given their power to destroy businesses and audit individuals, do you think it would be useful for the IRS to require all of its employees to take a class studying the Constitution and Bill of Rights in order to make positively sure that they understand the concept of government restraint created at our founding?
I think it's very important that IRS personnel be well trained.
Did you study the Constitution? You're a lawyer, are you not? Or an attorney?
I went to law school.
You went to law school. Did you study the Constitution?
I believe I took constitutional law, but I'm not prepared to take an exam at this time. Meaning, I'll answer any of your questions, but I can't promise, I'm an expert.
Expert. Well, you know the First, Second Amendment, and one of my favorites, the 19th, right? You know those.
Excuse me?
You know those
I
amendments.
I'm not.
The constitutional amendments. You know the first, you know the second, and you know the 19th.
I don't necessarily have the Constitution memorized, sir.
Okay. Well, they're pretty general. I mean, in what each one is. Like First Amendment is freedom of the press, freedom of religion, and freedom to petition the government for redress of grievances. First Amendment, right?
I really can't recite the Constitution, sir.
Okay. Do you understand do you know what the word T in Tea Party stands for?
I do not.
It stands for taxed enough already. That's contrary to what the IRS wants, I think, because they want to tax as much as possible, don't they?
The IRS's job is to administer the tax laws that are on the books.
Mr. Chairman, I yield back my time.
Would the gentleman yield?
Yes.
Just briefly, I want to make sure this gets properly in the record. Yesterday we had a transcribed interview and I'm going to ask unanimous consent to place at this time pages 189 and 190 in the record. Without objection, so ordered. And I would just read very briefly from it. This was to Ms. Paz. When we asked her about, did you ever accompany any other employees to their interviews with TIGTA? And she said, yes, I sat in on all the interviews, but the arrangement we had worked out with TIGTA was that I would leave at the end of the interview so they could ask anyone interviewed any questions they wanted to ask without anyone else present. So that was done. If that's correct, that her testimony that she was in at least what she thought was all the interviews, and that she left for a short time at the end.
I've been informed by staff that that is accurate, sir.
Thank you. And we went on with Mr. Hickson, one of my staff attorneys, asked, and he is an attorney, he didn't just go to law school, how did that arrangement come about when TIGTA approached you about conducting their audit? Did you request that you be present at all the interviews? Ms. Paz answered, yes, I believe, ... I can't remember if I made the request or Lois Lerner made the request, but we discussed that in order for the IRS to be able to respond to the report, we had to understand what information TIGTA had and what they were being told. Mr. George, you're a seasoned investigator. Those individuals who did that on your behalf, is that routine to basically let the target of an investigation/audit sit in so they know the questions and answers when they later may be a target of misconduct?
The operative word, Mr. Chairman, is audit.
Okay, so I'm gonna stop you there.
Yes.
Because this was an audit, it was conducted much more, if you will, like people coming in and just going through the books to find out, how much more taxes you owe, right? It wasn't conducted as an investigation.
That's correct. It was not conducted as an investigation.
Okay, I'm going to conclude later during the last 5 minutes.